Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists physician assistants with employment contract and independent contractor agreement issues. Today I'm going to talk about how restrictive covenants can affect a physician assistant termination. So, if a PA has decided to leave a job, or if a company has decided to fire the PA, how do those restrictive covenants affect your career after the fact? So first, let's talk about what a restrictive covenant is. A restrictive covenant could be something that you can't do either during or how most people think of it after the contract is terminated. So a non-compete, a non-solicit, non-interference, non-disparagement, non-disclosure, bunch of nons. And so these are the things you can't do generally after the contract is over with. So let's discuss those. The most important one is probably the non-compete. For a PA, it's very important that they limit the scope to what they're doing for their specific employer. And let me give an example. There are three components to any non-compete: the scope of it, meaning what you can't do, how long it lasts, and then in what area can't you do it in. Now, why the scope is important for a PA is a PA can do a bunch of different specialties. They don't have to be board certified in order to practice in an orthopedic practice or in primary care, cardiology, whatever it is. And so if you're working for an orthopedic surgeon in their practice, and maybe you're a surgical assist or you're just doing outpatient clinic work, you shouldn't be able to not practice as a PA in anything. I mean, there's no argument that can be made that a PA working in nephrology has any kind of competition with an orthopedic practice. But when I review contracts, it's usually a very broad scope, meaning they simply can't practice as a physician assistant. So you want to narrow the scope to what you're doing for that practice. So you would just say you can't work as a physician assistant in an orthopedic practice for 1 year and 10 miles from your primary practice location, something like that. That's very important for a PA, is limit the scope. Now, as far as non-solicitation of patients and employees, pretty simple. Most of the time that'll state you can't actively initiate contact to bring a patient with you to wherever you're moving to. And same for employees. You can't ask them to come with you and work at your new practice, or sometimes it'll go farther and say you can't even hire them or employ them in any way. But as a PA, most of the time you're not going to have that decision-making authority in whatever practice you go to. So I don't think a non-solicit is that big of a deal. Maybe if you're in primary care and you're opening up a practice just outside of the non-compete radius, that certainly could be something a practice would be concerned about, that you're going to come into the practice, build up a patient base, leave, and then yank all the patients with you. That's something that they would want to avoid. But the language of the non-solicit is certainly important. Non-interference kind of depends upon the specialty, but normally what this would mean is if maybe the practice you're working for is contracted out to a hospital to provide care, they wouldn't want you interfering with that contract. Or perhaps with referral sources as well. The non-interference may say you can't actively reach out to any of the referral sources that you receive patients from while employed with the employer, and therefore same thing, divert any of the referrals from the practice you're with to whatever your new practice is. Those are the main kind of restrictive covenants that can become a problem for a PA. Now, as far as terminating the contract, does it matter if you're fired for cause, fired without cause, or you terminate the contract without cause? Not normally. Sometimes we can get language that just says the restrictive covenants don't apply if the employer has terminated you without cause. But that's a tough one. Most of the time, the employer doesn't want that scenario. Now, 9 times out of 10, any kind of physician assistant contract is going to be terminated by the provider without cause. That's just the vast majority of contracts end that way. It's the PA wanting to move on, not them being terminated by the practice. It's just hard to find good providers, and so employers are just kind of willing to put up with some things that they may not normally be willing to put up with. And so the PA terminating the contract without cause is, 9 times out of 10 the way that it works. And in that scenario, the non-compete, the non-solicit, non-interference, they're always going to apply. There's not going to be a scenario where if you terminate it without cause that they're not going to apply. All right, those are some considerations of how restrictive covenants can be a problem for a PA after the contract is terminated. If you have any questions about an employment contract or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Take care.